All right, so to the extent the rest of this conference has seemed really tightly and rigorously structured, this is going to seem maybe a little less. This is kind of an open, John, come on up. Come on down. Do we have another chair? Yes, there's one at the end. This is really open, this is free play among those up here.
Sort of, yeah.
And those of you, I'll let the panel talk about things amongst themselves first, but then we'll go back to the microphone in the audience. And I guess I would start you off with a question or two. None of you has to answer this, although each of you is encouraged to. First, based on what you've heard, what you came in with, what strikes you as the most important lesson for how the U.S. should move forward with regulated genetic testing? That's the nice, broad, easy ones that you've all been thinking about that clearly has just one right answer, whatever that may be. And then a more specific one, actually triggered for me mainly by the last panel, but not entirely. Actually, it started with Kathy Hudson, is information. So to the extent that ClinVar and GenVar and the Genetic Test Registry are providing information, and the extent that information is crucial for regulation, are there information-heavy regulatory solutions that we should be thinking about in particular? John, I saw your hand up. So
I would just say across all these fields, the thing I've heard a lot of the participants say is that the regulation, whether for whatever form it takes, is a real problem if it's slow. And the regulation can come in the form of patent laws. If it takes 5 years to get through the courts and they get kind of a muddy result from the Supreme Court, that's not very good regulation. If it takes you 5 years to get an FDA approval for something, that's not very good regulation. It's important for the regulatory regime, whatever it is, to be able to move quickly enough to sort of keep up with the industry. Otherwise, the regulatory regime becomes a negative rather than I think it clearly can be a positive. I think we're optimistic about there being opportunities for it being a positive, but it has to be funded and it has to have a sense of urgency to be able to act quickly and act transparently and decisively. If we get muddy rulings that take years to come down, people just get frustrated, and the companies in the industry lose money, and you lose talent from the field.
Well, in the patent litigation space, I think 5 years is a little optimistic.
Yeah, we optimistic.
Can be. Okay, so any regulation has to be fast.
I just think
nimble, agile.
To be effective, it has to be. Otherwise, I think it'll still be there, but it'll end up being more. There's a balance between burden and benefit.
Right.
The slower it is, the more of a burden it'll be and less benefit.
Is there a standard still under development for buggy whips? Other thoughts? Stephanie?
I think another thing that we talked about over and over again during this discussion is the necessity for open and active communication among the federal agencies, CMS, FDA, and we really didn't really mention today the CDC. The CDC takes a very active role in clinical validity, so it would be very important to have very active and prompt communication among all of those agencies to be able to appropriately provide guidance to the laboratories.
Next. Go ahead.
There's one right there. Yeah, sorry. I just have been even surprised today with the variety of different settings. You know, I'm very used to the setting that I'm in, which is an academic and, you know, or turning into a reference lab type setting. But it's very different than what other people have talked about today. And I would say it really may not be a one-size-fit-all because just the complexity of the models, complexity of the number of types of testing, et cetera, as well as the complexity of the interpretation.
Yeah, I thought the match between LDTs and genetic tests wasn't very good, and that a lot of LDTs are not genetic tests, a lot of genetic tests are not LDTs. But I think actually whatever your vision of a genetic test is, it turns out that a lot of genetic tests aren't genetic tests, and a lot of genetic tests aren't genetic tests. There's so much variation in what people are doing that it is going to be a real challenge. Ewan?
I was very impressed by the extent to which the FDA were looking for dialogue and were looking for advice, and this has been, I think, a theme over the recent years, so I think we want to give credit for that. One of the things, though, I'm interested in is that it did come up, and it would be great just to hear the representatives on the panel speak. I mean, this idea of dual regulation. I mean, is the answer that the FDA has a remit to regulate, therefore it must, or is there an option not to do that because CMS could be expanded in order to perform those functions? I'd just be interested.
So I'm hesitant to speak for my CMS colleagues, so I won't, but from what I understand, they are not
All
interested in this
disclaimers are
job.
disclaimed.
Oh, yeah, and by the way, my disclaimer is that I speak for myself, as I learned from the lawyers. CMS is not interested in stepping up to that analysis of the clinical validity piece. So I don't, someone should do it.
Yeah, that makes sense.
And if they won't, it's kind of moot.
Can I respond to that?
Of course.
I mean, we have CMS, we have FDA, and then we have HHS. Why can't we go to a higher level? If CMS is digging its heels in the ground, where there could be a natural bridge between FDA and CMS. Again, what we're trying to avoid is dual regulation versus a continual regulation, i.e. of the laboratories, personnel, that's what CMS does, and FDA with the tests. That would be fine, but this dual regulation with the two agencies, and this gap in the middle, I think, why can't we appeal to the new Secretary of HHS? And I don't know if the agencies have, but,
So I don't think we feel it's dual regulation. I think we feel that FDA regulates the tests and CLIA under CMS regulates the testing service and the labs and the laboratories. And the extent to which FDA, when the test is not FDA approved or cleared, then CLIA has certain provisions for those. So we don't feel that it's dual regulation, and anything where FDA would be in the same space as a CLIA inspector, for instance, I think there's going to be a huge effort to work together so there's not duplicative regulation facing the labs, and that they don't have to fill out the same form for the same thing if one regulation is covered by the other.
Well, we're talking about clinical
Microphone,
validity, and clinical validity.
Gail, use the mic.
Yeah, sorry. I guess, CMS has already established the oversight for analytical validity, and to move the next component in producing a laboratory test, the three are analytic validity, clinical validity, and clinical utility. To move the next component to a different agency, why couldn't CMS do
But we're
this?
still talking about tests, and we're still talking about FDA's regulation of tests. And we do look at analytical validity and clinical validity. So it's not that CMS could extend to it, it's that we could do our job in this area.
But it's one entity. I'm a clinical laboratory. I have to now go to CMS, as I've always done.
But if it were an FDA
And
approved,
I also have to go to the FDA. That's dual regulation.
But let's be candid here. There's lots of areas where there are two, often in distinct departments within government that are responsible for different aspects of regulation. So, for example, FDA is responsible for some parts of claims that are made about drugs and some parts of advertising, and the Federal Trade Commission is responsible for some part of that. Do they need to talk to each other? Absolutely. Should CMS and FDA be talking to each other? Absolutely. In fact, they do. We started a molecular diagnostics interagency working group about a year ago, where folks from CMS who are involved in CLIA and folks from CMS, importantly, who are involved in reimbursement, and FDA folks from both drugs and from the commissioner's office, the deputy commissioner for policy, sit together and talk about trying to make this stuff coordinated. Coordination, absolutely, but to say that you can't have two agencies fulfilling their statutory responsibilities in a even way, I just think it's not a very compelling argument. To say that what FDA has proposed to do is not realistic, okay, but to say it's dual regulation, I just don't think that's the best, most compelling argument.
I'd add another realpolitik aspect to this, and this is not specific to HHS. It comes from my youth when I worked at the then new Department of Energy. I was a staff assistant to the Secretary of Energy. The Secretary of Energy had 20,000 people who worked for him. Secretary of Energy had 20 people who actually worked for him, and all the other 19,980 worked for various parts of it. And it wasn't as easy as him saying, I am the boss, you guys will do it the way I want to, both because of statutory obligations, congressional interests, stakeholder interests. So the fact that they're all in HHS doesn't necessarily mean that it's a particularly plastic system.
Although we do what Sylvia tells us to do,
I'm sure you do, Kathy.
for the record.
Because Francis is such an accommodating fellow who does what anybody tells him to do. Right.
I was going to make one observation about the regulatory framework. One is we're twisting the framework to try to fit the circumstances. And the circumstances, I can't imagine that we actually really mean that we're thinking about NGS sequencing as a test. And yet that's the framework that we're imposing on it, is using a device statute on one hand and a laboratory regulatory framework on the other hand, and we're now trying to apply it to a new technology that's can be way more fluid than getting your Huntington's disease test. So there's a frame problem there, and we wouldn't design the statutes from scratch if that's what we were trying to regulate de novo, but we're having to deal with it. And Congress can't fix anything, so that's not going to get fixed. That's a boundary condition. We're not going to fix it that way. So we're going to have to deal with it. That's point one. Point two is, one other thing that often gets lost is building the infrastructure is really, really, really important and can get neglected in all the focus on regulatory framework at the back end. But the front end is we need the infrastructure. We really need ClinVar to work. It needs the resources to do a good job of what it's doing. It's like we can't have the medical literature work without the National Library of Medicine anymore. It's just incredible. It's bedrock. So we need that to work. We need the pipeline that ClinGen is constructing to work. And that infrastructure stuff is every bit as important as the regulatory decisions that are being made that we've been talking about today, I think.
I just want to reiterate that FDA completely agrees that it is very important to have a resource like that that you can point to. So tests that come in, if the clinical validity is established in a database, that makes everyone's life easier. That makes the reviewer's life easier. That makes the test developer's life easier. That makes the clinician's life easier, the patient's life easier. So we're fully supportive of those kinds of efforts and involved in them as well.
I think Bob's point about this isn't how we would do it if we were starting from scratch is certainly true. If I'd had another half day for this conference, A, I would have gone crazier than I am, but B, I would have done a comparative bit to talk about how other countries are doing it, except it's not clear to me that other countries are actually any farther along than we are. I think they may be muddling along they even may be behind us, given the special health care system financing issues and the industrial issues. Now, it would be really interesting to know what's going on in China, for example. When China stopped all genetic testing for a few months, a lot of us wondered what was actually going on there. But I wonder if there is if anybody knows if there's another country other than the state of New York that is actually thinking seriously about this in a way that we might learn from. Anybody know of one?
The European Union has some things that are good, some things that are less burdensome. It's not that but they're still struggling with other things as well. But from what I've heard from manufacturers, okay, the traditional manufacturers, they can get something through Europe first, and then they work on bringing it to the FDA. So I guess, and I'm going out on a limb here a little bit, if the traditional manufacturers, the Roches, the et cetera, had a pathway that they could get their reagents through, could get them improved on a routine basis, et cetera. I mean, laboratories use FDA-cleared assays. If there's a good assay out there that a manufacturer is using, we will use it. If it's good, if it fits with our workflow, and if it doesn't double the price for us. So,
And if you can get reimbursed for it.
and that we can get reimbursed for it. So I don't know what the European Union's process really is. It's just what I've heard, is the manufacturers usually go through their process first, can get it into the European marketplace, and basically there are parts of the European genetic testing which is superior to the U.S. testing. So there are some indications, but I would say, why aren't we looking for the reasons that there are so many LDTs and that manufacturers haven't gone this route for some of these types of tests, and try to work with them as well, as opposed, we're doing LDTs because there isn't an appropriate FDA-cleared test out there. Why isn't there an appropriately, test out there? Many times it's because, should I say it? They're outdated before they get to market.
Because of the regulatory length of time.
Yes.
But in part, that's because the LDT pathway is available. Again, you can't say we're going to change one thing and not understand that it's going to change a lot of things. Also understand the European Union regulation is much easier right now. It's also going under significant revision because it's too easy right now. And everything that is brand new doesn't actually get very regulated in the European Union, and they've identified that as a problem. So I think there are other jurisdictions that we can learn from, Hank, but again, we can't talk about LDT regulation as though when it comes in, nothing else changes, because that's just not the case. And there's lots of cases where...
Evidence for that? Can you just give me your evidence for that?
Whenever you change a regulated environment, more than one thing changes. This is what we always talk about with unintended consequences of regulation. There's lots of things that change. If suddenly, as a manufacturer, I now have to go through the FDA no matter what to get my stuff into clinical laboratories, of course it's going to change my calculation. Of course it is. Absolutely it is. If I start a new company and I'm going to do a test for predicting cardiovascular disease, and I don't have a choice of going through FDA or not going through FDA, it is going to change the calculus on what I decide to do with that test and how many labs get to test that test. The root of it is in the finances. And if you take away the option about going to FDA or not going to FDA, you change all of the calculus. Of course it changes everything. Not the same decisions simply won't get made. They just won't. I've been in hundreds and hundreds and hundreds of these discussions. It will change.
Let me just respond to that. And that's a commercial entity talking about their financing for something. And the other thing that we've talked about today primarily is next-gen sequencing. We're talking about...
Gail, don't take my comment out of perspective, though. I'm not saying it's financially untenable to go through the FDA. That is not how that comment should be taken. That is not what I meant.
No.
It's just that you can't say one thing changes and nothing else changes. That's all I'm saying. And that's the basis of the anti-LDT, pure anti-LDT argument right now. And it doesn't hold water. It just doesn't.
Okay, let's stand.
But that should not, don't misinterpret what I'm saying. It's not financially unfeasible to go through FDA. Lots of companies do it.
Yes, exactly. And we're talking about Illumina, which is a multi-billion-dollar company, et cetera. But let's just stop that. What I want to say is that we've been focusing on next-gen sequencing a lot today. And one of the aspects I wanted to bring into the discussion was that the new FDA regulation goes back to 1976. So we're not just going to be regulating next-gen sequencing or one test or one platform. We're talking about the burden for laboratories going back to all the tests that have been offered since 1976 and at least notifying the FDA. That's my understanding.
So, Maya, come back up here.
LDT is not all the tests.
Well,
I can regulate
my
that.
laboratory is all LDT, so I'm talking about every test that I do, yeah.
I was going to try and be quiet. I really was.
I don't want you to be quiet. Have a seat.
So while Maya's going up there, Christina Capisti from UCSF, and I work on one of the newborn screening and DNA sequencing grants, and we had to submit pre-IDEs to the FDA. And going back to Bob Cook-Deegan's comment about NGS being seen as a test or a device, I think from the practical aspect of filling out the IDE for such a study, you're really shoehorning. I did the actual pre-IDE, and you're just really working to you want to answer the FDA's questions, but they don't quite apply, and you're working to shoehorn into it's not even outdated, it's just different. And it's also, I don't think FDA, at least in my understanding, isn't just regulating, the next-gen sequencer, they're regulating the pipeline that we're going through. So from the sequencing to the results and how we're verifying the results and the genes we're looking at and how we're giving them back to patients and so it's a whole pipeline. And that's just thus regulating as a device versus a test spoke to me, so I thought I'd share our experience.
Reaction.
I mean, I think we all know that NGS is sort of a different beast, and I think we have already shown that the FDA can be flexible with how it approaches it and put new ways of thinking about things on the table, and will continue to do that. Was the device law written for NGS? No, we're in a new place, and so we need to be flexible, and I think the agency will continue to try to be flexible.
It really is I teach FDA law, and one of the real interesting things about the agency is how the basic statute goes back to 1938. Actually, with biological products, it goes back to 1902. 06 is the Food and Drug Act. The Biologics Act is 02, and Jim the Horse, and who had diphtheria, who was being used for diphtheria serum, but unfortunately had tetanus as well. The ability of FDA over the years, with the allowance, complicity sounds too negative, but with the allowance of the courts and administrations to stretch and apply its statutory language broadly, has made things certainly much more flexible than they might have been had you had to go back to Congress every time something new came up. So stem cells are regulated as biologics. They're kind of biologics, but that wasn't what they thought in 1902. Lots of interesting, the ability of FDA to be flexible has been impressive. It doesn't mean that it is an unlimited ability or that it is an ability that doesn't sometimes have some downsides. But I wouldn't underestimate it.
Well, one of those downsides was the question I was going to ask about, which is to be nimble, to be flexible, and then to cope with the sheer volume of stuff that's coming. Presumably there needs to be more resources. I just wondered practically if what has been discussed around how you create an army of people who are going to be able to do this regulation.
I think those are good questions, and we don't know yet what the scope of LDTs that will fall under the required to come in for pre-market review, and I think we think there's probably, there's honestly no way of knowing, so, but if you look at the Class 3 devices that are in-house compared to Class 2 and Class 1, the vast majority are Class 2 and Class 1, like I think over half are Class 1, So if that held true for LDTs, many wouldn't have to come in. If depending on how the framework would play out and if it's finalized, the categories that would remain under enforcement discretion for pre-market review might be the vast majority of LDTs. We really don't know what the risks are because there is no systematic way of getting this information right now about how many LDTs are out there. So, and what they're really being used for and what they're claiming to be used for. Again, it goes back to the intended use. It's that risk-based framework that we will apply, that we apply now to medical devices, IVDs. And so when we apply that to the LDTs as they are run and as they are marketed, that may look totally different. We really don't know until we see that notification data.
Is the sense of the panel that most LDTs are for rare disease? Because I noticed that was one under which you were going to continue to use enforcement discretion.
Yeah, so this is one of our questions with the rare disease. So my understanding is the FDA is defining the rare disease as less than 4,000 tests, so not incidence of disease. If I'm wrong, please correct me, because I would love to be wrong. That it's the testing, the amount of testing, not necessarily the disease incident.
because of that, we do a number of tests to rule out disease, and that is also giving good clinical information, but that increases the number of tests. The other point of it, it says in the U.S., so I have no idea if my tests are going to be covered under a rare disease because I don't know how many Quest and LabCorp and Baylor and GeneDx and Indiana and, you know, I don't know how to get that number. So I don't know how many would be.
That's valid, and we would like to have that feedback for the record so that we understand. And your proposals for what makes sense in that field, I think we understand that when we're talking about rare diseases, we're talking about that balance of risk and benefit, having the test out there without these controls that FDA will provide versus not having the test at all. And so there is a balance there. We want your help, all, you know, the stakeholder help about how we set that that parameter. And if it's not 4,000 tests, and that is from the humanitarian use device exemption that we have in our statute already. So if it's not that number, tell us what number you think makes sense given the real world situation that you're dealing with. And we're ready to hear those numbers, and that's one of the points in the NOA that we called out was to comment on that in particular. We want to get those things right.
But as it stands, it is the number of diseases, just to clarify.
The draft framework does say,
Number
does
of
link
tests,
it to the
I'm sorry.
humanitarian use device, which is 4,000.
So I
And
want to
I
change
just, oh, sorry.
Sorry, go ahead.
I just, on that point, I noticed that there's a little bit of a, the definition of the HUD, what qualifies as an HUD doesn't match between the HUD guidance and the LDT guidance. The language is slightly different. The earlier one says something about the number of people who manifest disease, and the LDT guidance says number of tests done. And so we just think, you know, before we can really comment on it, we need to know which one it is.
I think you can comment on what either.
What it should be?
And,
Okay.
what you
Fair enough.
And yeah, you can point to what you believe should be in there.
I have a question. I know we have a voluntary registry of genetic tests. How different from that 35,000 do we think the universe actually is? I mean, how many of the LDTs that are all being done right now have voluntarily filed onto that registry? I mean, is the world 70,000, or is it, you know, we know it's at least 35, right?
One of the nice things about what FDA did here was basically say, we want to know what the universe looks like, and we're not going to charge people to provide that information to us. And they have at least indicated some openness to having our framework as the framework for that, so that you don't have to have two separate systems. But I think the question is, how many are there? And the notification requirement will provide that information.
Stephanie, do you have any evidence from New York that would be useful?
Well, I just want to back up in terms of a previous question about what kind of staffing will FDA require. And the first thing, it's not just about bodies to fill the position, it's about technical expertise in that certain area of laboratory medicine. They don't know the denominator yet. So yes, we're giving them data in terms of specialties, in terms of what we define as LDTs, which is far more broad than what FDA is looking at, and they're using that information to try to figure out just a baseline number. But FDA at this point in time, it would not be something that I would think they would be able to do in terms of technical expertise until they have a true understanding about what's coming, and they don't.
Can I mention our experience with the genetic test registry? So I think we have most of our inherited disease tests in it. We tried several different ways. So for example, we tried to work with them to give the behind the scenes information that we put on our website, and so that we wouldn't have to go and fill in forms for every test. I mean, the model that I'm under is that we have, hundreds of tests. It's not like a company that has 5 tests or 1 test that they're doing. We had hundreds of tests to get into this, and hundreds of, I should say, different ways that we may offer it. And so we tried to do it with the behind the scenes. It worked to a point, but not extremely well. So then we've worked with them in our inherited diseases to keep it updated, to keep it, work with it. Initially, we were told, you know, you can hire it, you know, this can be done at a technician level. That is not true. We have to have a minimum level of understanding of a genetic counselor. And that this has been given to our genetics counselors who are already overworked. And the genetic counselors are coming to us as the medical directors saying, we don't know how to answer these questions. And so now we as medical directors are doing it. I've been asked, you know, well, you know, you worked with us so well on the inherited diseases. We did, but boy, it was really painful. And now they're saying, you know, do this with your oncology tests, and I don't have any control over that. I passed that on. And truthfully, there's not any real enthusiasm to do it. So that's just the reality truth of the matter.
So I'm sympathetic to that and would point out that genetic tests would not be the only area where there is this tension between the burden of having to submit information and the benefit of having that information available. So we've been talking about genetic tests and devices and haven't really talked much about clinical trials, but there is a law that requires that clinical trial data be submitted to a publicly accessible database, which has, frankly, today, a terrible interface, horrible interface. It's very difficult to submit your clinical trials data, and very, 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 very soon, we will start implementing the law through regulations, which requires a $10,000 per day fine from FDA, and that a grantee, which is an institution, it's not you, it's Stanford, that is the institution, can no longer receive grant money from NIH, okay? This is a serious, serious expectation of Congress, and I think HHS is fully supportive that data be submitted. IOM is going to put out a report in December or January that says aggregate clinical trials data is great, but we want participant-level clinical trial data to be accessible. So I think this issue of the burden of being a data generator and then putting it, or information generator and putting it out there in the public domain or quasi-public domain, and then what are our responsibilities as federal agencies to make that easy and to support institutions to do it is a really important issue. It's not to say we haven't got it right yet. We don't have it right.
I just add, wearing another hat that I wear, I wonder about whether all those participants in the clinical trials knew that patient-level data was going to be made public in a way that, you know, the richer the data set, the easier re-identification would come.
And that's why we're revising the common rule.
and that's going to go through which decade, Kathy? Can I quote you? Can I? Okay. I got a $20 bill here. I want to throw something else out there. And when I set this up, we started it with Mark and with Ewan and with Megan, talking about analytic validity, clinical validity, and what I just made up on the spur of the moment, and I'm not sure it makes sense, but it sounded good, I thought, patient validity. Maybe because when we think of regulation, the word regulation conjures up particular kinds of processes. It doesn't necessarily conjure up IP, but Bob and Jake made a convincing argument that it's another regulatory method. Should any sort of regulation of genetic testing involve regulation of how patients are going to find out their results? And this is not, I am not a fan of direct-to-consumer, but this is not necessarily a dig at direct-to-consumer. Some of the things on the 23andMe webpage, the interfaces for patients, for customers, I think were really, really well done. Maybe it's a human, maybe it's a web interface, maybe it's a combination, but should someone, and I don't know whether FDA is the right one, should someone regulate how patients get informed of their results? John, I thought you might say something.
Yeah, well, I mean, one thing that is getting lost here is what's regulation supposed to do? It's to protect patients. And so we need to keep the focus on that. And I think that through this discussion, it's been very interesting that, you know, I think that a lot of harm is coming to patients, not at the lab level, but when you're actually trying to deliver those results and then implement them into medical management. That's where I think, as genetic counselors, I mean, that's where really we're seeing significant harm. And it's due to usually the individuals that are delivering that information and not doing it very well or misinterpreting a lab result. And so there are a group of providers that are going to get together and start to think about who should be delivering these services and differentiating. As I said earlier, you know, a physician under their scope of practice, they practice medicine. Hospitals, however, allow them to do certain things for certain patients. So I think that, you know, in this space, we need to pay closer attention to who is delivering those services, trying to differentiate those providers that do it really well and those that don't or don't even want any part of this. And so NSGC will be working with other professional organizations over the next few months, actually, to start to try to differentiate the providers that are actually qualified to deliver these services.
So you think the right hook is who, not necessarily how?
Yeah, to a large extent.
What if somebody were able to show that someone who is not in your category of who provides information, whether in person or online, that you know, you ask the patients 30 days later what they remember, and they remember more, and they make better decisions? Because it, again, as Jill knows, I've not been a real big fan of direct-to-consumer, but it is unfair to assume that the alternative to direct-to-consumer is perfection. Because as a patient myself, I know I forget. I hear what I want to hear from my doctor. Right. He doesn't want me to lose weight. Oh, wait, never mind. It's not a perfect system. Should we have a system that actually looks a little more at the results in terms of how well-informed patients are, and not necessarily at who's doing the informing?
But I don't think
so let's get you a mic.
But it's not just patients either. I mean, it's sometimes doctors.
Yeah,
struggle.
that was actually his point.
Right.
He didn't want to say it that clearly, but
Right.
he was actually doing that
No,
doctor.
right.
I mean, some of these risk scores, I mean, even the ones that have gone through FDA and are, you know, genomic health or things that are primarily used by physicians, not patients, I think there is a struggle with even physicians understanding how this gets done.
Oh, most definitely, and that is my point. You know, we have, I mean, genetic counselors who focus on cancer, they can't keep up with the panels today. I mean, they're changing daily. And so, you know, I think that will be FDA's challenge, is keeping up with that pace. And is it continuous regulation, or are you approved and then you can try to improve that test over time, but you're still approved? And then, I mean, so it's complicated, I think, in terms of the rapid pace of the technology. But providers, particularly non-genetic specialists, I mean, they can't keep pace with this. Genetic counselors, I think, have a hard time keeping pace with it sometimes.
And I do want us to remember that it can be the world's best test performed in the best possible way, but if the patient and doctor don't understand it and don't use it properly, we haven't accomplished anything. Jill.
One of the reasons that 23andMe brought me on is because I have you know, a long-standing relationship with the major professional societies involved in genetic testing and an open you know, lane of communication with them, and to actually, you know, open up those lanes of communication and say, hey, what are the things that this company has done that are actually, you know, kind of good, and how can we amplify that kind of good to really good, and what are the things that we've done that maybe could have been done better? And we've had fantastic dialogue since I joined the company 6 months ago. And one of the things that we keep hearing back is exactly what Hank said, is that we did a pretty good job of communicating this very complicated information back to a consumer. And we've been working in the last year to actually even kind of redo, how can we do that even better? If that's what we're good at, how can we do that even better? And working with each of these major professional organizations to optimize that for both provider education and patient/consumer education. So, I mean, that is something that I hope we can continue to work together with to do better.
Kathy, then Stephanie, or?
Don't leave me with the microphone, only bad things can happen.
Stephanie.
So with the new federal rule, we're receiving telephone calls from the laboratories. So the patients have access to their own test results, and they're asking the laboratories for the test results. Sometimes in hospitals, the test results are released as soon as the testing is done. Before the physician even has the opportunity to speak to the patient has now received, a pathology report, a genetic testing report, and the report may be quite complex. So now the patient can't reach their physician. The patient is calling the laboratory directly, and they're looking for that interpretive information. So it's in the best interest of the laboratory to try to, exactly as Jill said, make the language in the report as easy to understand as possible. But I can tell you from looking at these reports, holy crow.
Mark.
I'm going to offer up that in particular where we're talking about a process like interpretation rather than a test,
Right.
which is something happening in the laboratory, there are alternatives to hands-on regulatory activity or regulatory oversight. Documentary standards that are often sourced out of the professional societies or professional communities through recognized consensus standards development organizations are a viable approach that has worked elsewhere that can be maintained. And in fact, that if they're done in that fashion with an accredited standards development process, FDA can regulate, say, this is the appropriate standard to comply with. And that can be accredited through whatever, it doesn't even have to be CLIA accredited, it can be accredited through the professional society that, in fact, this organization is capable of delivering results according to this documentary standard and is certified, if you will. There are alternatives to just spinning down the drain, if you will, of everything having to be hands-on approved and put into a regulatory framework that may not be sufficiently agile to keep up with the latest cancer panel, the latest, so find the principles and find the process. And I think we shouldn't overlook that.
I just wanted to follow up on that, looking beyond traditional government regulation. I don't think this person who spoke for payers is here, but I don't know if people in the audience are familiar with what Palmetto has done with a prostate cancer test. I think it's called Confirm MDX. And they essentially said, look what the FDA does with its risk evaluation and mitigation strategies. They can limit prescribers or require certain certifications or training before you prescribe a drug. I think primarily looking at the drug context, or they can require a registry. Well, that's what we're going to do for this test. It's not coverage with evidence development in the Medicare sense because the patients aren't required to enroll in a trial, in research, but the providers do have to track the patient outcomes and share those with the payer. So it's an instance in which a payer is actually becoming more activist in trying to assure that a test is used appropriately, and also that in the absence of enough evidence to approve under the traditional framework, that evidence is created down the road.
That's really interesting. Kathy and then Jake.
So we were talking a few minutes ago about direct-to-consumer, providing testing directly to consumers and whether that information can be explained adequately, and now with the availability of consumers being able to access that information. And I was just wondering, I'm going to put you on the spot, I was just wondering if you could explain a little bit about what was the thinking that went on behind the infamous footnote number 4. And then I want to ask Jill, would you guys rather not have that footnote be there and then you're all in with this draft guidance and commenting on it, or what's your sort of take on footnote 4?
You go first. As I understand it, and I would like to make all the disclaimers possible now.
I'll protect you.
So it's my understanding that we never had a policy of enforcement discretion towards direct-to-consumer tests. And from if you look back from the warning letter, or it has come to our attention letters that first came out, it said, you look like a medical device, you are not in compliance, come talk to us, and that started the discussions. When those direct-to-consumer tests went from information for the consumer about certain things and it turned into health claims, that's when it stepped over into the territory of a medical device under that definition. And so at that time, we started having conversations with the various companies that were doing direct-to-consumer testing. So it was just to clarify that those are a different beast, and not to call you a beast.
Beast
Not
in
at all.
the nicest possible way. There's like almost nothing I can say here that's like safe topic, but
The weather.
that's it. But yeah, I know your tank's like, go, that'll make an interesting panel. I mean, I know that my company is really committed. We're committed to the mission of the company, and if it means we need to make changes to like maybe how we did some of the things in the past, we're open to that. We recognize that there are things that could have been done better, labeling things more clearly, pulling apart and separating this kind of information from that kind of information more clearly. We're very committed to working with the FDA to try to find a path forward because we are a very mission-driven company, and I think there is a lot of signal of potential good that has come out of allowing us to operate for 7 years and collect this amazing database of genotype, phenotype information. That's a huge resource to the entire genetics community. And we just got a $1.4 million NIH grant to actually make it even more easily accessible to the genetics community. We want to figure out how to amplify the good while working together with everybody to minimize any potential harms and to continue to study any potential harms and limit them. Footnote 4, we feel special that we got our own footnote.
I don't think there was any calling out of any. It was not about calling out any.
No, this is the only DTC company out there. Yeah.
At the time the guidance started to be drafted, there was more than just one company.
Okay, fair enough. That said, I mean, I think like a lot of parts of the guidance, everybody just kind of wants to understand better what does it mean. And then once we understand better what does it mean, then we can better determine if we can, if it's workable. And that's all I have to say about
So
it.
I would encourage everyone to sit in on the October 23rd and ask these direct questions, because I don't think this is the forum to get into specifics about the proposed framework or the footnotes. Thanks, Kathy. Sorry. But I do think that would be a time to get some of these specific questions answered about that.
So Jake, do you want it?
Yeah, I think it's not just in...
in the 2 years and 3 months I've known you, I've never seen you so patient.
Thank you so much, Hank. It's not just an information problem. I think it's also a labor problem, too. So as the number of people who are getting sequenced continues to go up geometrically, and as the amount of information that's produced from each sequence goes up, I don't know, I'm not a mathematician, exponentially, logarithmically, whatever the appropriate function is, very quickly, right? And you have to figure out a way to return these results to patients. There ain't enough genetic counselors in the world to do that. We see this a little bit at the patent office right now. There are not enough patent examiners to examine all of the patents coming through the patent office, and that is one of the reasons why we have so many crappy patents out there. So one of the things that we have to think about is a way to better the technological solutions we have to return data to patients. Now, whether you want to call that direct-to-consumer or not, we have to find a way to automate some of this stuff, if not really well, at least good. At least good enough that then people can turn around to genetic counselors if they have a serious concern and get a lowdown on exactly what's happening. I think if we're going to ask the question of whatever regulations that we pick, it cannot be, well, we'll always have enough warm bodies to do this, because we're not. We're not going to even come close, and in 10 years it's going to be laughable. So here is a plug to bettering technological solutions, and I'm glad that Jill's on the front line of this, and here's also a plug, if there's any undergraduates in the room, to think about becoming genetic counselors.
Yeah.
Well, and that's interesting. There are about 4,100 certified genetic counselors in the country today. Since 2006, it's grown from 75%. It's growing at about 5% per year. So there's growth, but we are well aware of this. There's discussions about how to create additional training programs and slots for those programs. But it is a challenge, and so we're thinking about ways to reduce the time a session lasts from an hour I mean, that's a typical session is an hour, so reduce it down to a half an hour, 15 minutes, and I think information is going to be key to that for sure. So it's stuff that is a concern, and we're focused on it. Right now, if you're a patient, wait times to a genetic counselor is very good. It's a week for an initial consult. So it's pretty good. If it's a stat appointment, you need to make surgical decisions. It's about 1 to 2 days. So access is good, but it's definitely, the workforce is definitely an issue.
So, well, as the only genetic counselor here, Megan, why don't you go ahead? And then John, and then you.
Okay, I just had two additional points to that. One, to further complicate, is not only as more people are getting genome sequencing and there's not access necessarily to genetics professionals to talk to about it, what do we also do about the fact that the data for all the people who have already been sequenced is changing so fast? So one other thing, because we definitely have patients coming back and saying, so I had a negative genome, an uninformative genome. No one has a negative genome because we all have 3.5 million variants, but I had an uninformative genome last year. What's next? When do I rerun that? And, you know, and then also family members. You kind of have the patient and you have the whole family becomes your patient. So just to further add to the complexity. And the other part was in terms of trying to determine ways that we can cut down on session times. And I think there's going to be a need for getting perhaps professional guidance on what are, and there already are recommendations like this, what are some of the important elements of the informed consent that needs to be talked about potential results. That type of thing I think could be for just the straight information everyone needs to know when they go into this test, the types of results that could come back, the standard incidental findings if you're doing this test, types of categories. That type of thing could potentially be something you have a representative video or something like that, or patient resources, you give them ahead of time. And I know from patients that I've helped consent, the people that I can point to resources ahead of time before our conversation in person, they have much more ability to ask targeted questions, have already thought about the results that they could get, how it might affect them and their family members, and those sessions are shorter and more efficient. So I think that, for me personally, will be very helpful, and I think strategies like that for the field.
John.
Yeah, so I guess I'd comment on a couple of the statements that were made before. Certainly the amount of DNA sequencing data that's being generated has been going up at an enormous rate. I think the number of clinically interpretable findings has been going up at a much slower rate than that. So you can, on the machines we have in our lab today, you can generate 1 trillion bases, in a couple of days. That doesn't mean you have that many more results than you would have had in the past. So I think the rate of amount of information that really actually is clinically important to convey hasn't been going up nearly as fast as the raw data rate. I think second point about the number of genetic counselors and how there never will be enough and so forth. We hire genetic counselors at our company, and we try to pay very market-based rates for that. I think our difficulty actually is not that there aren't enough genetic counselors. I think realistically, if I looked at different professions, the amount of training that many people who go into genetic counseling have prior to that's specific to genetic counseling is typically a year or two. So it's not the kind of thing where if there was a decision or even if there was an economic incentive to increase the supply, frankly, if the salaries of genetic counselors went up to a point that a lot more people were attracted into it, it wouldn't be a terribly difficult thing for the educational system in the United States to educate twice as many people, 5 times as many people, because we have lots of other specialty areas in the country where we educate many tens of thousands of people per year on things which are intellectually at a similar kind of level. So I don't think that this is really fair. And to be honest, most genetic counselors I think are not paid enough. And I'd say that perhaps more that the nuance is that a lot of people who have been through a program in genetic counseling have learned about interpretation of genetics as it was 20 years ago, and we find that very few get training on things that are at the genomic level. They haven't read the papers about the genome, and it's sensible that they're working on the classic Mendelian tests. They should know that. Those are important areas, but the education has to move forward, and I think it can move forward. So I think there can be a much larger number of people. So there are clearly others who want to speak about this, but I think
Ewan was next, and then
So I just want to thank John, first of all, for hiring all the graduates from our genetic counseling program. We try to keep some of the most talented ones, but...
You know, if you got some other names you want.
Right, yeah, no, you're not getting them. I just wanted to underline something. Megan pretty much said this, but I think creative solutions to this problem, while we train more genetic counselors, are important. I teach, as we all the academics here do. We have all, I think, noticed a difference. I go to teach the medical school class now, and there's nobody there because I'm talking to a camera. There are courses that our computational biology, bioinformatics folks go to that are taught by faculty who've actually left Stanford 3 years ago. Daphne Kohler's courses being one. So, and most of that is done by video, because what it would be that person standing up and doing the video. It can't substitute for all the training in the same way that it can't substitute entirely for genetic counseling. But as someone who got my ApoE counseling from the 23andMe website, you know, I can speak to the fact it was done extremely well. So.
Or so you remember.
Yeah. Too close to the bone.
So first to say is that the testing that I feel the most comfortable about in the entire process is when their genetic counselor talks to my genetic counselor. We make sure we get the right sample in at the right time, and we perform the right test and everything. When that happens and it works well, it works beautifully. We can save resources, healthcare resources, by getting an appropriate diagnosis, getting them into the appropriate treatment, et cetera. So there's the vision of what we're really trying to do. But with that said, we can't train our genetic counselors, and we're part of a training program at the University of Utah, and they train with us in the lab, and we do help them see genomic type data. So this is probably the only place that they really get down to do the interpretation. With that said, I would say we spend a lot more time training our fellows, molecular genetic pathology and clinical molecular genetics fellows. They are there 2 to 3 years with us on a daily basis, reviewing test results, going through these variants. We take that responsibility as laboratory directors. It is the board-certified pathologists, geneticists, other laboratory professionals that are the first tier of that interpretation. Now, given that we don't have all of the clinical information, we try to get the clinical information. It's not always easy to get. The best care is when the clinical talks to the laboratory to describe the clinical information. If I have that clinical information behind my results, I can do a much better job of interpreting it. We do take that on, and that's where we're saying the scope of medicine with the interpretation lies with the laboratory MD, PhD level people. We try to put them into reports that genetic counselors can then understand, or other MDs, and there are a lot that we are doing to not just geneticists, but to OBGYNs, to neurologists, a lot of work with neurologists, a lot of work with GI docs. And once they start working with this, they start understanding what we need. We start understanding what they need. The process really does work at that level. So I would say it's not just the genetic counselors. They have to interpret those reports to the patients. But there is board certification, a whole level of professionalism for MD, PhDs to do that interpretation. We are training the next generation, but it is intense, and it takes more than a month rotation in our laboratory. It takes a 2 to 3 year fellowship.
So with a panel of 17, it sort of felt to me like we had the whole audience engaged. But in fact, there is an audience out there. I think we have time for only 1 or 2 questions, because each question is likely to get 15 or 16 different answers. So if there's a question or two, this would be a good time. Identify yourself.
I'm Dimitri Karstad, a current fellow at the Center for Law and Biosciences, and Jake's replacement.
Replacement, I'm not sure that's the right word.
I'm not sure that Jake can ever be replaced, but I took
Jake's upgrade?
I'm not sure you can say that either. But I want to pick up on something that was said in the beginning. I think it was actually an underlying theme throughout the conference, and that is enforcement discretion. Now, it came out explicitly in the FDA's presentation, and maybe implicitly in the Myriad case, maybe we wouldn't have the Myriad case if Myriad wasn't so aggressive. So my question is, the flip side of enforcement discretion are doctrines like latches and estoppel in the law, and that is when you make other parties believe that through your words of conduct, you're not going to enforce a right that you have against them. Maybe you forfeit the ability to enforce that right. And I'm not suggesting this is happening here around LDTs and so on, but I wonder to what extent, to the extent that law reflects social norms, FDA worries that this might be happening. You have an unregulated industry that develops around not enforcement, and then industry on the flip side worries that this might be happening to them, and so they proceed on assumption and make investments that they're unregulated. So it's kind of a little bit of an open-ended question, but to a legal person, this is something I found pretty interesting.
Ethan? I'm picking you out as the lawyer for
the other lawyer sitting up here? Okay.
Well, the lawyer with the commercial side. I think Mary and Jake and I are all lawyers. But.
Well, I think in some ways your question was addressed in an earlier question or statement where we have to recognize that all the decisions that are being made, the decisions to invest, the decisions to pursue certain business opportunities, the decisions to file, the decisions to utilize the LDT pathway are all intertwined. And so if we alter any of those, we necessarily will alter a whole set of decisions. That doesn't necessarily mean it's a bad thing. It just means we have to understand that. And I mean, so to your question, I do think that corporations now, as they're rational, corporate entities, are looking for opportunities to maximize the return on their investment and perceive one pathway of regulatory involvement as preferred over another pathway. And if that's going to change, that's going to alter their decisions. We just have to accept that.
Carol.
So I had a lot of questions come through my mind with this panel, and a lot of them were addressed. Now I just have a headache.
There's a cure for that soon.
I just thought I would say great job to Hank. Really terrific group, a panel. It's really been like a think tank, an incredible opportunity, and my hat off to all of you, really, to sit there together and talk this through. It's a tough issue, and really, great job.
He wants something from me. I'm not sure what. The last question.
I'll second that. Ron Ariano again. I think the last discussion that the group has had, the group of experts, really focus on what I would consider the correct focus of needing the expert in genetics to do the analysis of the perfectly provided results from a laboratory to guide the presentation of that information to a patient. It gets a little complicated when you're talking about consumers. I think when you have an interface in which you don't have a medical model involved, it's going to be, if you will, problematic. It even gets more problematic, and this is the question that I'll ask, is that a lot of discussion has been held about regulations to have the formulation of the best laboratory and validation of the way the laboratory tests are done and how it should be done with the FDA and CLIA and so on and so forth. However, we have to be realistic. There are labs out there that are not CLIA approved, and let's say they come up with medically pertinent information that is possible of making a serious medical decision. What do we do with those kinds of laboratory data? Should they be given to the patient?
Anyone want to take that? Somebody with a microphone say that.
My point of view would be no. That they weren't. No, I mean, there's not the controls in place to know if that's real information.
But this happens all the time in research studies. I mean, in genetic studies for decades, we have found things. I mean, I haven't been
exactly.
doing.
That's what I'm talking about. Or university laboratories are always creating new laboratory tests.
But the answer is that you then send the patient to a lab to have a clear study of that position and that variant, and at that point, a medical intervention can be made on the basis of it. So it happens all the time, actually, where we find this on. We do a genetic study with a whole genome study, We scan someone's genome, we have it interpreted as if it was a medical test because we're interested in analyzing an N of 1 kind of study, but we can't, and we may even at some extent, this is where it gets very gray, share that with the patient, but we can't make medical decisions on it. The only people who can are the ones who've received the results of a CLIA test. So we send the patient to another physician generally. Megan, I think, mentioned this story of a patient who had exactly that situation with a BRCA variant earlier, and they went and then were inside of the system, had a CLIA test done, and then medical decisions were made.
Elaine?
So I also have sat with NHGRI discussing the return of research results. I was completely shocked because my understanding is that any result going to a patient needed to be performed in a CLIA, under a CLIA setting. So I'm sitting here, is this even happening? And a lot of it is happening, you know, but this is the NIH level talking about it. And how do you return these genetic information? And, you know, I've been involved enough that as a CLIA lab, we've worked with studies so that when they wanted to return clinical information, they then worked with us to then send it out. But with that said, that needs to be really from sample to result because it's the entire procedure and not just a test. So with that said, then it's like, okay, we're a CLIA laboratory, but there are times that you need to do extra work to see if you can understand this. Most commonly, it's a splice variant that we want to see if it causes, you know, aberrant splicing. All we need to do is get RNA instead of DNA and start looking at it that way. We can do that, but that's not under a clinical laboratory now. It is under a research laboratory, and yet it's also illegal for us to return a research result through a CLIA lab. So, I mean, you know, my understanding through all of this is that results only go through a CLIA laboratory if they go to a patient. But evidently, that's not what's happening.
I think the concept we talked about earlier in the FDA context of enforcement discretion sometimes may get applied to the CLIA requirements, whether
CLIA wouldn't support that.
I understand that.
Yeah, and neither would NIH. There was a long period of time where very senior people at NIH thought that research was different and we could give data back from research laboratories. That's no longer the case.
CMS has a series of presentations out there which really describes the difference between clinical and research. And they are, and I'll give you an example. There's a laboratory located outside of the U.S., and it's performing very specialized genetic testing. And we had a resident in New York that wanted their specimen tested by that laboratory, and CMS said, absolutely not. They do not have a CLIA number, therefore they may not result specimens. So, I mean, there are unintended consequences to performing patient research testing that's not anonymized. But you have to result that sample from a CLIA lab.
But our consent form says, you know, thank you for participating in this study. You know, you have the right to all the results from the study. And that's traditionally always been the case for participants in research studies in university environments. So that's what we've been struggling
So at NIH, we say that too. And our labs, we have insisted that our labs get CLIA certified. So there was lots of objections 15 years ago, especially in the institute that I was in, the Genome Institute. And we asked CMS to help people walk through the process of getting CLIA certified, that if we were going to be returning information that could be used in a medically actionable way, that we needed to play by the same rules as everybody else does.
But you then are going to end up in certain situations. For example, I have to call a patient back and say, I've found something and I need another blood sample, but I can't tell you what it is. I do think it's important that you need to have a CLIA test done, and that'll take 6 weeks, but I can't tell you what it is.
Have your lab get CLIA certification.
So now you suggest every single lab that has a PCR machine at Stanford is going to get CLIA certified?
It's doable. It's a problem.
I don't think that's doable.
So I will tell you that there are labs who have PCR machines that I would be very anxious, and I think somebody else said, you mentioned earlier about CLIA actually came here. Well, there's labs where CLIA hasn't come that are even worse. These rules are in place. CMS is very clear. There's not exceptions. If you want to not obey the rules, then don't obey the rules.
Oh, no, but I think I don't think this is exactly
And
covered.
as far as I know, no one has been sent to prison for violating
Nobody is making
the CLIA genetic testing rules.
Nobody is making medical.
Or fine, right.
Nobody's making medical decisions on the basis of a non-CLIA test, just to be very clear. Right. But if I have a patient in a study where we measure their heart rate and they say to me, can I take a look at what my heart rate was? I'm going to show them what their heart rate is. And so, but because this is... And no, their heart rate measured with my fingers on their pulse. You know, I don't believe
wait. You're not FDA approved?
Let me check my suit.
What's your lot number?
That's
No, I think clinically, investigators would be the physician scientists. If we find a test result from a research laboratory that has medical significance, we would have it repeated in a CLIA lab. I think the practical problem, however, is how are you going to pay for it? And that's something, if it's important enough, we figure that out. But basically, medical decisions should be made on approved tests, and we would agree in principle for that. But just for people to know, I mean, this is a noise in the system that's going on. It's a way of advancing our knowledge as well, because maybe some of the tweaking and so forth of the technology that the universities are using may lead to new information as well, and that's creativity that I don't think you want to take out of the picture.
So we've reached the stage of the proceedings called conclusion. I was supposed to start at 5 and end at 5:15. It's now 5:14, but I'm still going to try to end at 5:15. Because conclusion is actually two things. One thing is thank yous. First, and clap loud for this because they're outside the door, our program group, Trish Gertridge, Jody Carrion, Brittany Thayer, and others are the reason we have a nice facility and we have food and drink and usually the audio and the video work and all that great stuff. And John back there doing the video. We rely on these people year in and year out, and they do a spectacular job for us, and I hope you've appreciated their effort. So a round of applause for the program group. A round of applause for the speakers. And now this calls only for the speakers. A round of applause for the audience, at least those of you who have stuck with us. And now the actual conclusion. I've been involved in law and genetics issues since 1992, when I was 6 years old, more or less. And I've thought for a long time that genetic tests need some more regulation than they've got, if only to prevent the complete quacks from taking advantage of people, but also to try to minimize the harms and maximize the benefits. But the first time I thought about this, I thought, back in 1998 or so, boy, that's going to be really complicated. And then a few years ago, in 2010, FDA issued a letter when Pathway Genomics was trying to do a deal with Walgreens drugstores, and I thought, they're going to do some regulation. That's going to be really complicated. A little earlier, the Secretary's Advisory Group called for regulation, and I remember reading that call and thinking, that's going to be really complicated. I set up this conference in the hope that I would conclude, well, it's really complicated, but it's not that complicated. I'm not sure that's actually how it ended up, but we humans are good at complexity. It's what we create. It's what we do. It's what we are. It's what we create. We can find a way forward. It won't be easy, but one of the things that really encourages me is with people from lots and lots of different segments up here on the podium. Everybody wants to do the right thing. And everybody, at least so far, has at least openly said that they want to work with others to do the right thing. We will not have a perfect system for regulating genetic tests, and it may be that the system we end up with doesn't change very much from this one, but the process of thinking about it, of trying to apply it, of working our way through the complexities, I think we will be better off than we are now, and I think part of that will come from efforts like the people up here and the people down there working together to try to take this wonderful new technology and maximize its benefits at relieving human suffering while minimizing the inevitable but inadvertent causing of human suffering that it does. So go away from here not just confused at a much deeper and more profound level, but charged at a deeper and more profound level to make this work. We can do it. We need to do it for our sakes, our children's sakes, and our grandchildren's sakes. And now, let's drink. Thank you very much. And eat too.